Welcome to the website for International Criminal Law at UCL. In these slides I'm going to spend about 10 minutes going over some of the introductory material for the course and outlining a brief introduction to some of the historical material we'll cover in early classes. So to begin with, how's the course structured? In Term 1 we're going to focus for our first couple of weeks on the history and institutions of international criminal law, so we'll be looking at the various courts and tribunals that exist now and have existed, and also the fundamental law of jurisdiction governing when states can take responsibility for prosecuting international crimes. We'll then spend the second half of the term dealing with what we call the core crimes: genocide, war crimes, crimes against humanity, and aggression. Then in the second term we have a number of different topics. We'll spend just one session on transnational crimes. Usually we look at torture, terrorism, and piracy. And we use the phrase transnational as these are generally crimes prosecuted before national courts and not international courts. We then look at the general part of international criminal law, so that part of international criminal law that applies across all the different crimes. So rules of liability, defences such as duress, insanity, superior orders, the rules of procedure, rules of immunity from state jurisdiction for, say, heads of state or serving high officials, and rules governing state cooperation, both between states and with international tribunals. We have an in-class simulation of the International Criminal Court, and then wrap up the course talking about issues of theory, and we have an emerging issues class covering new developments and also revision before the exam. So I just want to talk briefly about the nature of the subject. As this quote captures, the basic difficulty in approaching international criminal law is it requires both a strong grounding in international law, and it is derived from the sources of international law. But it's also criminal law. So as we have it here in the Cryer and others textbook that we use, as the point I want to make is that this is not theoretically an easy course. It's a course that involves both a knowledge of general public international law and concepts from international criminal law, and we'll also be drawing on concepts from humanitarian law, the laws of war. So it's not as simple as looking up the rule and applying it to criminal conduct. And we can't escape these issues of theory, they're quite important. Also, a fundamental concept in international criminal law is complementarity. International criminal law will never primarily be enforced by international courts. There aren't enough, and they don't have the capacity to prosecute everyone ever suspected of a war crime. So it's a branch of international law which is designed primarily for enforcement by international courts. It ultimately relies on national courts in order to enforce it. The other question we've got to deal with is, how do we define international criminal law? What's the scope of our subject? So a broad approach would just say, well, it's any crime defined by international law. But what do we count then as international law? If we count every crime outlined in a treaty, then our subject includes topics like damage to undersea submarine cables, which might seem rather trivial for the term we use, for the term of international criminal law. A narrower definition would focus on the idea that it covers crimes within the jurisdiction of an international court. Even then, that's not perhaps very theoretically sound, it's just descriptive. We're just saying, well, these are the crimes that historically have been prosecuted before international tribunals. And as I said, we'll also look briefly at the concept of transnational criminal law. And essentially we can think of these as crimes against national public order that involve an international element. So typical examples would be drug smuggling, migrant smuggling, trafficking of persons for sexual exploitation, money laundering, and of course piracy, which typically affects national order in the sense that it will involve an attack on one state's flag vessel, but it has a strong international element in the sense of the offence undermines the safety of world trade and freedom of navigation on the high seas. We'll spend a certain amount of time in class, but not a great deal of time, on basic ideas of the sources of international law. Customary international law, treaties, general principles of international law, the writings of eminent publicists, and the role of jus cogens. If you're not familiar with this, if you've not done a core public international law unit before, then we can recommend some additional reading. But certainly you'll find some of this reasoning difficult if you've not done a public international law class before. And we'll talk a little bit about the way treaties and custom relate to each other and the role of the ICC statute in our course and why we refer to it very often as evidence of the law. Another thing which we need to consider are the purposes of international law, the ideas that underpin it, what it aims to do, and in terms of its aims, whether there are alternatives, whether international criminal law is always the best way to address, say, a post-conflict society or issues of justice following mass atrocity. So a fundamental question are, what are the objectives of international criminal law? What does it aim to do? We often say that national criminal law, for example, is about deterrence. Well, how realistic is it to expect that the existence of international criminal law will deter leaders from committing war crimes? We also will spend a certain amount of time talking about nullum crimen sine lege as a basic principle in international criminal law. And sometimes a lot of the criticisms made of international law revolve around this basic legal principle. So nullum crimen sine lege is, as we have it here, the principle of strict legality. And it's well explained in Antonio Cassis's second edition of his book on international criminal law. In civil law countries at least, nullum crimen has four elements. Specificity, the idea that offences should be spelled out clearly and in detail. The prohibition on retroactivity, we shouldn't punish conduct that was not illegal at the time. And the requirement that criminal law be enacted in written form, and that crimes should not be extended or applied by analogy. And we can debate the extent to which international criminal trials at various times have violated or have risked violating some of these rules. There's also a separate principle in most national systems, nullum poena sine lege, which is the idea that criminal sanctions must have been envisaged at the time a rule was enacted. It's not enough that you've broken a rule to punish you criminally, it must have been a criminal rule to begin with. And an important point in international law is not every rule of, for example, the laws of war envisages criminal sanction. So it might not be enough that someone has violated an article of the Geneva Conventions. We have to ask, well, is this violation criminalized as a war crime? And stepping back, we also need to think about alternatives. Is international criminal law always the best solution or response to a situation of mass atrocities? We can consider other possibilities, such as amnesties, often used by states as part of a peace process or under the rhetoric of allowing everyone to put a period behind them and move on. Truth commissions, lustration, which is basically sacking everyone associated with an old regime. Civil claims, in effect, individuals suing those who tortured them or committed war crimes against them. And traditional law, indigenous courts, as happens Nuremberg, its origins and its significance. This is Justice Jackson, the lead prosecutor at the Nuremberg Tribunal, and it's one of the iconic images, perhaps, and attempting to indict leaders for crimes committed in the 20th century in the course of a war. But the transformation that we normally think of Nuremberg as having made in international law is that before 1945, international law was thought only to apply to the state, and the state provided a hard shell, as it were, around national affairs. So if you wanted to punish an individual, they could only be punished under national criminal law, my picture on the left. After 1945, we typically say, well, international law doesn't stop with the state. In both human rights law and international criminal law, international law can reach through that hard shell of the state and affect individuals. Individuals can be defendants in international courts, and they also have rights under international human rights law. And we'll talk a bit about the way Nuremberg was set up, not initially an inevitable outcome, and some of the other plans that were proposed by Churchill, Roosevelt and Stalin instead of prosecutions at Nuremberg. So the Nuremberg trial itself is historically quite interesting. Nuremberg was in part chosen for symbolic reasons. It had been the place where the Nazi racial laws were promulgated, but at the end of the war it had been entirely devastated by Allied bombing, with, however, the exception of a still functional courthouse with a significant prison attached to it, and that was one of the reasons it was suitable for running the Nuremberg trials. And there we have a picture of the courtroom from Life magazine in the 1940s. So some of the issues we'll explore about Nuremberg is whether trials were legally established, whether international law actually recognized crimes of individual responsibility at the time of the trials, and also the difficulty that the concepts of a crime of aggression, of waging aggressive war, and crimes against humanity were undoubtedly very new at that time and may have violated nullum crimen sine lege. There are also, it's also important to note that out of all the crimes within the jurisdiction of the Nuremberg Tribunal, genocide was not a crime prosecuted directly at Nuremberg. Also, one of the advantages Nuremberg had over later proceedings was the enormous documentary record left by the Nazis, and that's not something we always find in later trials. I'll skip over for this presentation questions arising from Tokyo and other international proceedings, but one of the things we need to reflect on throughout the course is that we've taken certain lessons from the Nuremberg trial, and those are that international criminal prosecutions are practical, viable and good ways to respond to mass atrocity situations, that they can establish an historical record. But we do have to question whether they're always worth the enormous expense, whether they can really be conducted outside of a situation of occupation like occupied Germany, where all the evidence is under an occupying power's control, and whether they can really work without cooperation from the state in which the crimes occurred. And we'll consider some more theoretical critiques of international criminal law as well. That's really all I wanted to say by way of introduction. Thanks for listening, and I look forward to seeing you in class.